And just with the time that we've got remaining, I'd like to ask all of our panelists for their key takeaways or their final thoughts. Fernando, we started with yourself. Perhaps you want to lead us off with a few of your key takeaways.
Well, I try to stress the point primarily that it's very, very important to have specificity regarding what the ingredients are doing individually and in combination, as well as what is really the effect of a process component on the product. And one concept that is often missing in considering both materials and processes is the fact that when you enact a manufacturing process, you are creating structures. Products have structures. And the use of specific structural attributes along with methods to test those structural attributes can be a very effective way of defining precisely what the invention is achieving and defining much better who's infringing and who's not.
Thank you so much, Daniel. Perhaps a few key takeaways from yourself as well, please.
Okay, yeah, to apply all of what I discussed, I would recommend when drafting applications on monoclonal antibodies and chimeric antigen receptors is to provide as much structural information as you can on as many antibodies or receptors as you can, so that you have enough written description to cover a broader claim. And then also place as much data as you can on a therapeutic effect, binding affinity, or other physical property of those antibodies to help you out in Europe with inventive steps.
Thank you so much. And Brian, you are our final speaker today. Perhaps you want to close us out with a few of your key takeaways.
Sure, thank you. I think my main takeaway here is that given the current state of federal circuit law, most typical diagnostic claims are going to be per se unpatentable under Mayo. Again, the exception being if you really need to develop a novel technique to complete your method, there might be a path forward. Fortunately, however, the federal circuit has opened up some alternate pathways in expanding the patent eligibility of methods of treatment and this new method of preparing type of claim. And so to the extent you have a diagnostic product that you want to protect, you do have different avenues for protecting that in these other method types. Again, having to carefully consider how you draft a claim to consider things like divided infringement. But there's at least some hope that for some diagnostic products can be covered, just not by the traditional diagnostic method route.